meeting now, or with our inquiry now. I welcome everybody in this room. I'm not going to call you by your names or by your organizations, but everybody is welcome. We have an agenda in front of us. I think we have apologies. Can we get the apologies first?
Thank you, Chair. It's the following apologies. Mr. Nkwankwa, due to illness, is unable to attend the meeting. And then also an apology from Mrs. Nobanda, who is delayed, Chair, but she will be joining us. Those are the apologies, Chair.
Thank you very much, and apologies are being accepted. Honorable members, today we are going to get our witness is already here. He is going to give us evidence on corporate governance in Eskom, how Optimum coal mine was purchased. He's going to be a little bit detailed. I hope we are going to be as patient as possible so that we get what we want from him, what we invited him for. Today we are getting a presentation, therefore we are not going to be led by the evidence leader. We will just give over to give over to our witness and to present. Is the witness going to present? The witness is going to testify, and the evidence leader will lead him to testify. We are not going to have a certain time. We will give them enough time, the evidence to the evidence leader to lead the witness up to where he will indicate that he is finished. Hopefully we agree on that, members. Now I will give over to the evidence leader. Are you ready? Oh, he is going to speak under oath. The evidence that he's going to give here is going to give us under oath. I will therefore read the oath to him, and then he will then sign the oath after that. I just hope he's going to hear me clearly, because there is this noise that is happening, and I'm told it is sorted. I just hope that was the last chair or the last wheels that went on top of this roofing. Okay, it's fine. I'm speaking to you now, sir. In accordance with Section 16 of the Powers, Privilege and Immunities of Parliament and a Provincial Legislator Act 2004, as a witness to this oversight inquiry, please be informed that by law you are required to answer fully and satisfactorily all questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath before a house or committee may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17, subsection 2 of the Powers, Privilege and Immunities of Parliament and Provincial Legislature Act, a person who willfully furnishes a house or committee with information or makes a statement before it which is false or misleading commits an offense and is liable to a fine or imprisonment for a period not exceeding 2 years. You are required to take an oath that the evidence you are about to give is truthful. You may choose to take, okay, you said you are going to take an oath. Then this is the oath. I swear that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. Can you raise your right hand?
I swear that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. Then I will now give over. You signed, did you sign?
I've just signed it right now.
Okay. Then I will now give over to the evidence leader.
Thank you, Chair, and good morning to yourself, the honorable members, and the guests of the committee. Mr. Marsden, for the record, can you just state your full names and provide the committee with your academic background and your working experience?
My name is Piers Michael Marsden. I am a chartered accountant with 15 years of experience working in the insolvency industry. I have a postgraduate qualification diploma in insolvency. I'm a registered senior business rescue practitioner at the CIPC, and I have done many business rescue assignments.
The committee has requested your assistance in relation to a transaction which was the purchase of Optimum Coal Holdings from Glencore by Tegeta. I would like to just ask you to explain to the committee what was your involvement with Optimum Coal Holdings, when that involvement started, when it ended, the capacity in which you were involved in. Were you alone in the assignment that you were with? Also take that further to one of the subsidiaries of Optimum Coal Holdings, which is Optimum Coal Mines. When you got involved with the mine and in which capacity you got involved, and whether or not you're still involved with that relationship. Thank you.
Thank you and good morning, and to the Chair, honourable members and guests, thank you for your time. In answer to the question, this is a matter that really came to my attention a couple of weeks before the business rescue application was lodged, which date was the 4th of August 2015. Myself and a colleague, Peter van den Steen, who has given me a letter of support and authority to appear here, and he is supportive of my actions and attendance here today, were effectively communicated by the board of Optimum Coal Holdings as well as Optimum Coal Mine, pursuant to a resolution passed on the 31st of July 2015, effectively where those two legal entities passed a resolution for the voluntary business rescue. I was formally appointed by the CIPC on the 4th of August 2015, at which point my involvement with the entities began. The business rescue process, and I'm not sure if anybody in the committee has any experience or requires me to go into any detail around any specifics of business rescue, but as a overriding process, it is designed to facilitate the rehabilitation of companies and essentially to place the management and operational control of those legal entities into the hand of an independent third party, in this example myself and Mr. van der Steen. Pursuant to our appointment, we understood and tried to gain a better understanding of the financial position as well as operational position of the various entities. From a structural point of view, and to the extent it's necessary, I do have an organogram which would assist the members to understand the legal process and where the items fit. But at a simplistic level, Optimum Coal Holdings is, as the name suggests, a holding company, and it had a number of different subsidiaries wholly owned, Optimum Coal Mine being the principal focus, but included within the other subsidiaries was Optimum Coal Terminal, which had the significant rail allocation through the Richards Bay Coal Terminal, the Quinfontein Mine, as well as a number of other subsidiaries which had various mining and prospecting rights. Effective from my appointment, we understood very quickly that Eskom was going to be a fundamental player in the process. They were at the time the only customer for Optimum Coal Mine, which had a long-term coal supply agreement with Eskom, and as is much publicized, was a loss-making coal supply contract. There is an extensive history prior to my involvement, which I won't bore the committee with. It is detailed quite extensively in the Public Protector's report, but it did involve a long-term supply agreement, a hardship, a cooperation agreement signed to try and find some level of agreement between the parties, and ultimately that sort of resulted in a situation where it had been approved at various levels within Eskom, but at the highest levels of Eskom the agreement effectively failed. A penalty was applied on Optimum Coal Mine, and as a result of that the company was financially distressed, and that was the reason why the board of directors applied for business rescue.
Sir,
Yes.
you speak about the penalty. Are you aware of the amount of the penalty and what the penalty was for?
Absolutely. The amount of the penalty, and really there are two components to the penalty. The first component, in the amount of about 2.1 billion rand, related to historic coal deliveries where product had been delivered to Eskom allegedly out of specification, and if my memory serves me correct, the specification was largely around the sizing of the product. The real concern, however, was the forward-looking review of the penalty, i.e. if the penalty were to be applied retrospectively, then looking forward, and if Eskom were taking the view that they were going to apply those principles, the mine would be even further loss-making, given that it would effectively not receive value for the product that it had delivered. So understanding that Eskom was a critical part of any plan to resuscitate the business, for the period of the next effectively 2 months, a variety of engagements were held, not only with Eskom but with also other affected parties in the business rescue process. Those issues included discussions around the supply, the ongoing supply of product, various pre-litigation items, various proposals made by myself and my fellow practitioner with regards to the supply to Eskom going forward, discussions around the loss-making contract, and a variety of administrative actions effectively that we were doing as part of our business rescue process. Essentially, this was designed to ensure that we could avoid a liquidation. There were substantial numbers of people employed, principally at Optimum Coal Mine, but of course if its holding company went into business rescue, which it had, it could also have an impact on the other subsidiaries, being Quinfontaine, where there was significant employment. As a result of that, we had extensive negotiations with Eskom around proposals, around the supply, around proposals in terms of ongoing adjustments or amendments to the coal supply agreement. There was a termination of supply, which was then effectively resuscitated and supply continued by mutual agreement for the duration of the business rescue proceedings. That proceeded for the month of August, and essentially for the month of September as well, and we concluded an interim arrangement in the middle of September 2015, whereby the parties agreed to work together to try and find a solution to the onerous contract. In or around the 5th of October, it became apparent to us that a negotiated settlement around the coal agreement was unlikely to happen. In fact, we received written confirmation from Eskom that our proposals had been rejected in terms of restructuring the entity in its current format with its current shareholding. We then decided to pivot and effectively see if we could change the paradigm by introducing a potential purchaser for the mine. And on the 7th of October, on or about the 7th of October, we signed a binding term sheet with a third party. We had received numerous unsolicited requests to buy the mine. but we had at this point in time only just decided to move into the second phase. Prior to that, we were trying to negotiate a settlement, and included in those unsolicited offers was an advance made by KPMG on behalf of Tegeta. On the 7th of October, however, we decided to sign with a third party, which agreement effectively had as one of the hearts and core parts of the agreement was that that third party needed to find some solution with Eskom to enable us to overcome the problem of the onerous supply agreement. Towards the middle and latter part of October, that transaction failed. We again implored Eskom to try and find a solution and to resolve the impasse, which would have seen not only the saving of several thousand jobs, but also the continued supply of product to Eskom.
Sorry, Mr. Marsden.
Yes, of course.
You're referring to a third party. You're referring to unsolicited proposals to purchase the mine that you turned down. Are you at liberty to share who these parties were that made these unsolicited proposals to you?
I'm pretty sure I'm not at liberty to, so I'm happy to disclose it. I think that the agreement that was signed, the term sheet that was signed, was with a company called Pembani. There were a variety of other unsolicited offers, none of which we had accepted. The only one we accepted was the Pembani offer, but the unsolicited offer did include entities like the state-owned mining company, as an example. Towards the latter half of October...
The Pembani supplier or proposal, which you'd signed the timesheet, why did it not proceed? Why did the transaction not proceed?
At the time, we were not given detailed reasons. Further on in the process, we received a letter from Pembani confirming that they had not been able to get sufficient answers from Eskom in terms of a proposed transaction.
So as business rescue practitioners of Optimum Coal Holding and Optimum Coal Mine, you were prepared to sell the Optimum Coal Holding with its subsidiaries to Pembani, but that Eskom did not agree to the transaction. Do I get that correctly?
Just one minor correction. At this point in time, we were very much in discussions around Optimum Coal Mine. Optimum Coal Holdings was in itself a holding company, and as such did not have any liabilities other than the bank debt which was stayed as a result of the moratorium. So at this point in time it was very much a discussion around Optimum Coal Mine and the sale of that asset. But other than that, you're correct. We had signed a term sheet to sell Optimum Coal Mine, subject to, of course, the usual commercial agreements, to Pembani.
And was there any specific reason that Eskom gave to you as to why it would not agree to the sale of Optimum Coal Mine to Pembani?
No, I was given no reason.
In your interactions with Pembani, were they given any specific reasons by Eskom as to why they wouldn't agree to the sale of the mine, Optimum Coal Mine, to Pembani?
I was not privy to the discussions between Eskom and Pembani, so unfortunately I'm not qualified or able to answer that.
I thought you said you had received confirmation from Pembani that Eskom did not agree to the sale of the mine, or did I misunderstand you?
No, you're correct. I had received a letter, as I said, not at this point in time from a chronological point of view, but later, once we had concluded a transaction with Tegeta, we did receive a letter from Pembani, effectively suggesting that they perhaps had not been given an opportunity to do a similar type of transaction. But they did not detail any of their discussions with Eskom. So towards the latter part of October 2015, we once again implored Eskom to reconsider, given the potential liquidation that would have had disastrous impacts on employment as well as the ongoing supply. And with various correspondence, essentially we realized that we had better engage with further parties, and essentially we were left with Tegeta as the remaining offeror for the assets. They requested us to facilitate a meeting between themselves, that is Tegeta, and Eskom, to see if a deal could be crafted. And at a meeting on the 24th of November, chaired by Eskom, effectively Eskom's position was laid out pretty clearly in terms of what a transaction could look like that they would be supportive of. That essentially involved a transaction not only of Optimum Coal Mine, but effectively the transaction that was ultimately concluded, which is a transaction that included both Optimum Coal Mine as well as the profitable Quinfontein Mine and the profitable Optimum Coal Terminal. And on that basis, Eskom was prepared effectively to look at a transaction. So effectively moving our gaze from being focused exclusively at Optimum Coal Mine to a much higher gaze, effectively involving the sale of Optimum Coal Holdings' entire set of subsidiaries, including Optimum Coal Terminal, as well as Quinfontein Mine. The rationale for that being that effectively there was a profitable side of the business and a loss-making side of the business, and Eskom's view, quite correctly I think, was that the one business needed to support the other business, and they did have a guarantee effectively from Optimum Coal Holdings. So they believed that the business would only be sustainable if it included both the good and bad sides of the business. That effectively kicked off a number of discussions with Tegeta, in terms of which we had received, as I mentioned, that meeting was on the 24th of the 11th. We received a verbal offer to the tune of R1 billion from the Tegeta consortium. We had a meeting with the banking consortium, who had security over the assets and who would be another important party in making sure that the business rescue process was concluded. This would have seen them taking a substantial write-off on their debt, and as a result they rejected the original offer on or around the 26th of the 11th. Following a number of discussions, effectively late in November, perhaps on the 1st of December, Glencore decided that they would rather support Optimum and discharge the business rescue. A meeting was held at Eskom, at which this decision was made, subject to, of course, being able to restructure the bank debt to the tune of about R2.5 billion. And a meeting was then subsequently held in early December with the bank to let them know this fortuitous piece of news and the fact that ultimately it would resolve a restructure of their debt, but Glencore supporting the business going forward. Then on the 4th or 5th of December 2015, we received an amended offer from the Tegeta consortium, which effectively was the deal that was ultimately concluded. That deal was concluded on the 10th of December 2015. It includes a substantially increased purchase price, and it had an effective date of 1 January, but with 4 conditions precedent to the transaction, which needed to be met by the 31st of March 2016. One of those conditions precedent was the Competitions Tribunal giving their consent to the transaction, which was handed down on the 22nd of February. The second was a letter of comfort or a guarantee from the purchaser, effectively demonstrating their ability to deliver on their purchase price. In that regard, we received a letter on the 4th of March 2016, which is one of the specific items requested and is included in your packs. Sorry, just to highlight, the sale agreement is also in your pack as specifically requested. So that dealt with, although not entirely to the satisfaction of the banking consortium, but that effectively saw that condition precedent waived. And then on the 30th of March, we received the last two, which was Eskom's release letter and consent to the transaction, as well as the Section 11 consent from the Department of Mineral Resources. Thereafter, the business rescue plan was published. It was published on the 31st of March, and a meeting was held on the 8th of April 2016 to approve the plan, which subsequently happened, and the plan was approved. Essentially what this meant was that the purchaser had 4 days in which to deliver the funds, and the seller had the same amount of period to effectively deliver the shares and to deliver the change of directors resolutions, the administrative documents, effectively to an escrow agent to enable the transaction to close. That was on the 8th of April. On the 11th of April, and I don't know if I can just briefly touch this because I'm sure this is going to be the subject of much questions, but on the 11th of April is effectively the subject matter of the Section 34 that we have effectively lodged. So I'm going to maybe skip over that and we can come back to that in perhaps more detail. So the 11th of April we had a variety of meetings, but ultimately on the 14th of April the transaction closed, and Tegeta became the new shareholder of Optimum Coal Mine, Quinfontein, as well as Optimum Coal Terminal. At that point in time, Optimum Coal Holdings, having divested itself of all of its assets, effectively was discharged from business rescue. However, Optimum Coal Mine, still in business rescue, continued to trade as such until the 31st of August, when we discharged it from business rescue as a result of it no longer being financially distressed. That is effectively the end of my involvement with Optimum, the 31st of August 2016.
31st August 2016 or 2017?
16.
Can we then get back to the 11th of April 2016? There were developments on the day. Can you just take the committee through those developments?
If the evidence leader doesn't mind, if I could maybe direct, it's probably easier for me to read directly from the statement, in terms of the statement that was issued to the Director of Priority Crime Investigations. It'll, I think, perhaps help me form my words a little bit better. That is in the pack that was specifically requested. I've given quite a bit of the background.
Sorry, Mr. Marston. In our PAC's advocate, the information is not numbered. There are dividers in between, but the information is not numbered. Can either you advocate or Mr. Marsden give us the top part of that document that he's going to read out of, so that we all go to that document? Thank you.
Absolutely. So it is in my folder, the blue one. I'm not sure if it's the same in yours, but essentially it has the SAPS logo at the start.
Yeah, Chair, I did inspect the annexures, and one of the documents that is missing is the Section 34 statement, which I have asked the committee secretary to just make a copy for the committee members, because I don't know whether it was because of haste or what. No, it is here. It is under the pink file, but on top you'll see there's a copy of the South African Police logo. Yes, under the South African Police logo there you'll see
in our packs it is there, but it's not in the same. Maybe the color of the divider would not be the same. Yeah, for all the packs.
Okay.
I saw it.
It's a green divider in some.
The others are not grey. It's,
No,
it's,
but you can't say no. This is green. So don't say mine is wrong. Say yours is wrong.
I said the colors of the divider will not be the same because mine is yellow and Mondli's is green. Yours might be pink, so and the others might be blue.
Colors are different. I've got the green.
Okay. Anyone?
Have you got this? I've got it. Hey, it's a.
The easiest way is to say that the divider it's number 5. It's divider number 5 in our packs.
What I like about it, it's non-racial. It's got many colors.
It's not 5 to you, PG. It's 6. All right. Okay.
It's impressive. Abantu be-ordered, asifake emvubeni nje. Kuyobe sizokukhula emvubeni.
May I proceed, Chair?
You can proceed. Thank you very much.
you.
And thank you for your help,
No,
Advocate.
So if I could ask you to page through effectively the first couple of pages, which simply are administrative, and get to the page effectively titled Directorate for Priority Crime Investigation, Anti-Corruption Desk. Points 1 effectively through 9 are covered in terms of the background that I've given. So I'm going to pick up from point number 10, which is the sale agreement was subject to the fulfillment of certain suspensive conditions. These suspensive conditions were fulfilled and or waived on the 8th of April, thereby rendering the sale agreement unconditional. The purchase price was required to be paid by Tegeta to the attorneys as escrow agent on the 3rd business day after the date in which the sale agreement became unconditional. The 8th was a Friday, so effectively taking us to the 13th of April. I received a phone call from Mr. Hauer of Tegeta on the 11th of April 2016, effectively 2 days before payment was due under the sale agreement, requesting a meeting at the offices of Tegeta in Sandton on such date. That meeting was held on that date at approximately 10 in the morning. At such meeting, I was advised by Hauer that Tegeta was 600 million rand short in respect of the purchase price, and he requested myself to approach the bank consortium to request a bridging loan in the amount of 600 million rand to finance the shortfall on the purchase price. The purchase price was in the amount of about 2.15 billion that was required effectively from the purchaser. At 1:30 on the 11th of April, I arranged a meeting with the consortium of banks. The meeting was attended by representatives of the consortium of banks as well as Glencore, at which meeting the consortium of banks requested me to advise Mr. Hauer that the banks were not prepared to finance the shortfall of the purchase price. I took this message effectively back to Mr. Hauer after deliberation. It was at approximately 3 o'clock on the 11th of April. And as I mentioned earlier, on the 14th of April, the amounts were paid and the purchase price had been discharged. The deal therefore closed. On the 12th of June 2016 and the 19th of June 2016, Carte Blanche aired a feature on this transaction, which precipitated the release of various press articles. A full-length interview with Hauer was also made available on the Carte Blanche website on the 20th of June. We reviewed the episodes and the interview in the week of 20th of June, and we reviewed the articles. Pursuant to the episode, interview and articles, we learned for the first time that Eskom had made a prepayment to Tegeta for the purchase of coal from Tegeta in an amount of 586 million rand. The coal for which the prepayment was made by Eskom appears to have been or is to be procured from Optimum coal mine for Tegeta and delivered by Optimum to Eskom's Arnott power station. We have come to learn from the episodes that the prepayment was approved by a committee of Eskom representative at a meeting at 9 o'clock in the evening on the 11th of April 2016. This meeting was held on the same day in which the request for the bridging finance of 600 million rand was made to and rejected by the consortium of banks. Pursuant to the interview, Howard remarked that the prepayment has been made on the basis that OCM was in business rescue and required money for its liquidity and for the start-up of equipment. We confirm that the prepayment was not made to OCM and that OCM provides a 30-day payment term to Tegeta for the delivery of coal. We are mindful of Section 34(1) and our obligation to report any suspicious activity. We do not intend to draw any conclusions from the aforesaid, but wish to draw the attention of the Hawks to the circumstances of which we are aware as a matter of caution. We reserve our rights to provide supplementary documents, and the content of this letter is private and confidential.
You then wrote to the Directorate for Priority Crime Investigations. Actually, this letter that you just read was addressed to them. I see it's signed by your core business rescue practitioners, correct?
Signed by both of us, correct, yes.
You, in page 3, paragraph 23, you're saying you're reporting what you perceive to be a suspicious activity. What was the basis of your suspicion?
I think everything has timing and context. Mindful of our meeting that had happened prior to the discharge of the purchase price, on the 11th of April, we were led to believe by Tegeta that they were 600 million rand short on the purchase price that they needed in order to close the transaction. And the timing of the prepayment was on the very same day, in fact at 9 o'clock in the evening, for an amount relatively similar. So the amount was for 586 million as far as I can remember. And so we believed that the timing of that was something that required further investigation. So both the quantum and the timing required further investigation.
Perhaps it would be opportune at this stage just to indicate to the committee who are the shareholders of Tegeta.
There is a detail effectively included in both the competitions filing as well as in the Public Protector's report. So please don't hold me if I'm a couple of percentage points off. But certainly Oak Bay and the Duduzamna Zuma's company, I think it's called Mabelengala, are the majority shareholders. But if you give me a couple of minutes, I'll be able to find who the detailed shareholders are. This is on page 112 of the Public Protector's report. But effectively, the percentage shareholding of Tegeta is Oak Bay 29.05%, Mabelengala 28.53%, Fidelity 12.91%, Accurate 8.01%, and Algasol 21.5%.
Just on that page, who owns Oak Bay?
I obviously have no personal knowledge of who owns it, but clearly it is the investment arm of the Gupta family.
The 586 million rands, which you refer to on page 2 of your letter to the DPCI, paragraph 19.1, as a prepayment to Tegeta. Read that with paragraph 21 of the same letter on page 2, where you're referring to the remarks made by Mr. Hoa. In light of the two, in whose account would the 586 million have had to be paid to?
So we had no knowledge of the 586 million rand. We were not in control, certainly, of Tegeta. However, as mentioned, post the close of the deal, Optimum Coal Mine remained in business rescue from April until the 31st of August 2016. As a result, we were certainly in control of that legal entity, and Optimum Coal Mine did not receive the 586 million rand. Subsequent to the close of the transaction, Optimum Coal Mine entered into a sale agreement with Tegeta for the supply of coal to the Arnott Colliery. But at the time of the prepayment, certainly that payment was not made to Optimum Coal Mine. And in fact, on the date that the payment was made, if the public protector's numbers are correct, the payment was made to Tegeta, which was not the shareholder of the mine at the time either. It merely had a right to acquire the mine.
In your view, as the business rescue practitioner of Optimum Coal Mine, where should the 586 million should have been deposited? Into whose account should that money have been deposited?
I think, first of all, the rationale for the money would need to be interrogated in the first place. Optimum Coal Mine was in business rescue, so clearly was financially distressed. We had, however, negotiated better payment terms on the Hendrina contract. This coal supply agreement was between Tegeta and between Eskom. It was not between Optimum and Tegeta. It was, of course, back-to-back, subsequent to the prepayment, in terms of an agreement between Optimum and Tegeta. So in terms of a very Optimum Coal Mine point of view, we never supplied the coal to Eskom. We supplied the coal to Tegeta on 30-day payment terms. So the prepayment was a transaction between Tegeta and between Eskom. And the issue that we had, or we took with regards to the various interviews, was that the rationale given for the prepayment was twofold. First of all, that the company was in business rescue. As I've mentioned, we didn't get that. Second of all, that equipment was required in order to mobilize and increase production. We were currently in control of that mine, and whilst there was a modest amount that was required in order to restart a second drag line, it certainly wasn't anywhere near the quantum of 586 million rand. I hope that's answered your question.
You're probably not aware, but I am aware that there was a 1.6 billion guarantee from Eskom, which assisted in the facilitation of the payment of the purchase price. Are you aware of that amount of money?
Just from the press.
So in terms of the payment of this particular transaction, you as business rescue practitioners, and I've had a look at the contract relating to this purchase of shares and rights, you are one of the parties to this agreement. From the explanation, it would appear that you were in the dark as to the source of funding for this transaction. Is that correct?
The ultimate source is incorrect. When we concluded the transactions, one of the conditions precedent was that the purchaser demonstrate to us that they had the financial ability to conclude this transaction. We were effectively given a letter of comfort from their bankers that they did have the funds available in order to conclude this transaction. So we relied on that letter in terms of concluding a transaction. The ultimate source of the funds that discharged the purchase price only became known to us and effectively predicated this Section 34 declaration.
Clearly, and this is very apparent from your statement to the DPCI, and assume that it's a package that informs your suspicion around the activities on the 11th of September. That there is a meeting between yourself and Mr. Owa in the morning. In the afternoon around 3, you report back to him that the banks whom you had approached have considered his request unfavorably. And midnight on the same evening, there is a board tender committee meeting, which you had at the time no knowledge of. Not surprising, because you are not a board member of Eskom. At night on the 11th, the BTC approves this 586 million rands. Now those are the facts. What I'm interested in pursuing with you is the following. Mr. Owa was not a board member at Eskom, is that correct?
Yes, I believe so.
The purchasers were not, and still are not, directors or board members of the Eskom board.
As far as I understand, that's correct.
That the meeting gets to be convened by whoever, and surely that meeting must have been convened by members of the board or relevant members of the board tender committee. And that board committee then deals with the prepayment, which later forms part of paying the purchase price. If I were to put it to you then, and I would like your comment on this hypothesis, that Mr. Owa must have control over the people that convened that board tender committee that evening of the 11th of April 2016. What will be your response to that?
I think that the timing and the quantum certainly look suspicious, but the hypothesis is something I think above my pay grade in terms of whether they have control. We certainly raised the issue. It certainly doesn't look fantastic. I think if you look at it in the context of the Public Protector's report, particularly the communication between Mrs. Ragavan and Mr. Molefe at that point in time, there is certainly something that requires further investigation.
Maybe the word hypothesis scares you. Maybe let's use common sense. There must have been a relationship which you and I seated here now and here cannot explain. But this relationship from the purchasers, because surely if they are to get 586 million from Eskom, you see, if the banks that you had approached were to give Mr. Hoa the 600 million, it would have been because you were approached, you went to the bank, and the banks would have agreed to loan the 600 million. Is that correct?
Certainly that was the request that was made of me.
Now you and I seated here might not know the role players, but it would appear that somebody must have initiated this special odd meeting on the same day, that evening, for that meeting to take place.
I would imagine that meetings like that do require notice, and certainly the commendable work ethic to meet in the evening, but I have no knowledge around what required timeframes, notices Eskom's internal meetings have. It may have been called earlier, or I have no knowledge of that.
But we know, I know, let me not say we know, let me say I know that before your meeting and your response to Mr. Hoa on the 11th of April 2016, there was no special board tender committee convened. Now, certainly to look at the prepayment of the amount you've requested, or you've stated in your statement. So that you can accept from me. So I'm saying, if the 586 million paid the purchase price, those in need of the 586 million would have had to approach Eskom in one way or the other for them to get the 586 million, in the same manner in which you were requested to approach the banks.
That appears to be correct. I think that the convening of the meeting I have no knowledge of, so to the extent I'll rely on your statement. It does seem an extraordinary large amount of money to not only approve but to pay down within a relatively short amount of time.
And at this stage, you and I might not know who approached who, but we know that somebody convened this meeting, and the sole issue on the agenda was this particular matter. So, it's an issue how the meeting was convened and what was to be discussed and all those things. I'm not going to bother you with those. Eskom board, particularly the board tenure committee members, will have to deal with those. But what I'm interested in, just using common sense, the meeting then gets to be convened, and we know now the money was paid, contributed to the purchase price. Would you then say, directly or indirectly, Eskom contributed to the purchase price for the purchase of the mine?
Certainly that's the conclusion that the former public protector reached, and it seems pretty unequivocal in terms of the flow of funds as detailed in her report.
You reported this to the police. I'm just looking at the date. That's what I'm trying to find. When was this reported to the police?
The 1st of July, 2016.
It's now over a year, 3 months. Have you had anything from the Directorate for Priority Crime Investigation regarding this matter?
I thought you might ask that. We received an acknowledgement of receipt immediately on the 1st of July as we reported it. Immediately as we reported, so 2016 we received an acknowledgement that it had been received. In May, between the 18th and 23rd of 2017, I was contacted by a warrant officer for further particulars, which culminated in a 34-3 affidavit that I signed, almost identical to the one that you're looking here. Yes, in May of 2017, between the 18th and the 23rd. Those interactions culminated in me signing a further 34-3 affidavit in July 2017 with a warrant officer, and then as recently as Thursday of this week I received a further email from what appears to be the new investigator requesting a further interview, and I've been here, but I hope to see him in the next couple of days.
So the first meeting was to record your letter in a different format, in the form of an affidavit. Do I understand you correctly?
That's correct.
And that was just over 8-9 months after you had lodged your letter.
Correct. So the discussions commenced. My earliest record is the 18th of the 5th, 2017. There were a variety of documents that we required to ensure that we were dealing with the correct parties. And ultimately there was a meeting held and a further affidavit signed in July 2017. The original application, 1st of July 2016.
Given the developments around the 11th, and looking at the shareholders of the purchasers, do you have any reason to believe that the prepayment of 580 something million had anything to do with who owned the purchaser.
I've got no knowledge of that. I wouldn't be able to comment.
So your only concern about the transaction are the events on the 11th of April 2016, which you became aware of much later.
I think that is the principal item that we were concerned around. Throughout the transaction, we encountered a particularly acrimonious relationship that we effectively inherited when we started Business Rescue with regards to Eskom, and it was quite difficult to engage with them on a meaningful basis in terms of trying to find a solution for the business rescue of both the coal mine and coal holdings. This could have been ascribed to playing hardball, this could have been ascribed to many commercial rationale, but it certainly was not an easy transaction. We had formidable players in the game, both from Eskom, the DMR, and Glencore, so it was a particularly difficult transaction.
Let's go back to the 2-point-odd billion fine. Where did that, what happened to the fine? At the time that you were business rescue practitioners, and at the time of the sale, and according to your knowledge, at the time that you closed the business rescue practice.
So the fine was one of the principal reasons for the company entering into business rescue for both Optimum Coal Mine, which was effectively had the long-term supply contract, but Optimum Coal Holdings had also signed a guarantee for the obligations of Optimum Coal Mine, hence the reason for Optimum Coal Holdings going into business rescue as well. One of the advantages of business rescue is it effectively puts a stay on legal proceedings, and the view that we took throughout the business rescue process was to effectively use that shield of the business rescue process to avoid having to litigate on that particular matter. I think that the fine itself is an item that was subject to much technical dispute and would have required extensive arbitration, not only from a legal point of view but also from a technical point of view, to determine the veracity and or the quantum of the claim. In terms of the purchase, that liability remained with the legal entity. So Optimum Coal Mine as a legal entity itself was acquired by Tegeta, and effectively that issue was kicked down the road post the end of the business rescue. So throughout the business rescue process, we effectively used the stay on legal proceedings to not deal with it in terms of arbitration and or litigation.
Before you decided to sell the mine, and later the holding company with all its subsidiaries, this issue of the fine, which had brought the company into the situation that it found itself in, which, as you have reflected, was subject of a lot of technical discussion, negotiations between the shareholder, which then you came into the picture with Eskom. What was the attitude of Eskom towards the fine?
Throughout the process, Eskom's attitude, and I think it's important once again to reiterate, the component of the fine is twofold. The 2.1 relates to the historic coal that had been used. perhaps more relevant is looking forward, in that if Eskom were to apply the strict criteria going forward, you would, for the remainder of the contract, you would have a quantum far in excess of the 2 billion as well. So it was a fundamental issue, and certainly each purchaser, and if we go back to some of the items we've covered already, the fundamental issue was that there needed to be satisfactory resolution, not only to the 2.1 billion fine, but also in terms of the contract going forward and the couple of billion rand that could ultimately come out of that. Eskom's position, I think, has been laid quite clearly down in the press, as well as in various correspondence that we have, in that their expectation was that the fine needed to be settled, and they were pretty unequivocal around that.
Surely you must have engaged with the shareholder, that is Glencore, when you took over, particularly around the issue of the fine, because that brought a lot of burden and strain on the business. What was the attitude on the fine?
I think the fine itself is an item that could have been arbitrated on. I think that there were many legal protections included in the agreement, and those mechanisms had been applied prior to the business rescue. The hardship clause, the agreement, the cooperation agreement signed between Optimum and Eskom prior to the business rescue. And ultimately their view on the fine was that it's a bit like going to a restaurant and eating a steak, and when you finished it, asking if you don't have to pay for it because you didn't like it. You know, there's a certain view around the fact that the product was actually utilized. I think if product's out of specification, you say take your product back rather than consume it. So the issue around the fine, and certainly Glencore would have had the stomach to continue to fight that and arbitrate on it. The real issue is around the ongoing obligations. If the attitude persisted around insisting on those particular items, there would be very little liquidity in the business, because effectively your customer wouldn't be paying for the product supplied. So that is perhaps the more relevant component of the fine. With regard to the attitude, I always believed that the former shareholders believed that the fine itself could be argued, and there may be a component of it that was valid, but the vast majority of it could probably, in an arbitration, be resolved.
And that position was put to Eskom, and that notwithstanding, Eskom was adamant that the fine, the historical fine, had to be settled.
Eskom wished to arbitrate in the business rescue process. We believed that we certainly didn't have the liquidity to mount a substantial arbitration, so we used effectively the business rescue to not get into the matter. But of course we did have discussions with Eskom around the resolution of the fine, and as stated many times in the press as well as in various correspondence that we have, they remained adamant that that fine should be paid in totality.
What will you then be your take? And because there will be evidence laid before the committee at some stage, and you would not be around, and I would like to afford you an opportunity to comment on that state of affairs, particularly with the knowledge that you possess around the negotiations on the fine. That subsequent to the sale, the successful sale of the mine and the holding company with the other subsidiaries, that fine in excess of 2 billion rands, which Eskom was adamant that it had to be paid, that fine had been reduced to less than 600 million. What will be your take on that?
I think really two aspects to my response. First of all, I think the speed at which it was resolved was a surprise. We believed that it would involve extensive arbitration, argument, counter argument, technical evaluation, legal argument. So that's the first comment. The second comment is that I think we always believed that there was an element of the fine that in detailed legal and technical discussion would be overturned. So that's really my only comments on it.
Earlier on you testified that what was to be sold was Optimum Coal Mine. And later on, Eskom insisted on the sale of the entire, of the holding company together with its subsidiaries. And you then said, at the time it made sense to you. Does it make sense to date?
Just to maybe rehash why I thought it made sense to me. I think that the other mine within the group, Quinfontein, was reliant on Eskom to be a customer for the Komati power station. And it would seem unusual for Eskom to suffer a loss on the one hand and contribute on the other. So certainly our view, given that Eskom had the holding company guarantee, was that that made prudent financial sense from Eskom's perspective to ensure that their in-the-money contract balanced their out-the-money contract. So certainly that made a lot of sense, and from an OCT perspective, the rail allocation is clearly a valuable asset. In terms of where it currently sits, and once again I lose all visibility on the 31st of August, so I have no personal knowledge of the current state of affairs, but it certainly does appear as if the other parts of the group have either been sold or are in the process of being sold. I can't comment whether those deals have concluded or not, but that kind of goes in the face of the rationale in terms of which those profitable assets are needed to support Optimum Coal Mine to fulfill its obligations till the end of December 2018 in terms of the loss-making agreement.
So effectively, if the Richards Bay is the mine that is or the subsidiary, the Richards Bay subsidiary of the Optimum Coal Holding, which is making money, which makes sense for Eskom to say, we need to balance, we need to get both the money making and where we're bleeding. If the Richards Bay component is sold, what will be the effect of that selling be on Eskom's financial position vis-a-vis the situation where that the Richards Bay subsidiary is part and parcel of this holding company?
So Eskom has a guarantee effectively from Tegeta, which replaced OCH in the structure. I think post December 2018, if Optimum Coal Mine had delivered in 100% compliance with the agreement, there would be no financial effect. If it were to be sold prior to that, and those funds were then allowed to be discharged to shareholders or whomever, and as a result of that, Optimum was not able to deliver, Eskom would not have the ability to look towards the profitable assets for the performance of the shareholder for its subsidiary. So it's all around timing. To the extent that those assets are dispersed of, and Eskom does not act on its guarantee for the obligations of Optimum Coal Mine, potentially it may be in a bad position, but this is all speculation.
No further questions.
Thank you very much to the evidence leader and Mr. Marsden. My apologies for keep on forgetting the surname. Members, we are about to ask questions. But what I would want to get clarity on, Mr. Marston, is the meeting of the 11th of April. In your statement, you are saying that meeting was a meeting of representative of Eskom. You are not specific in saying it's Eskom board, it's the executive of Eskom. You are saying it's a representative. Is it possible that those representatives are people that had an interest in the transaction, or people who would not even know what the transaction was about? Can I just get clarity on that?
Thank you, Chair. The meetings that I attended on the 11th was with Mr. Hawa at Tegeta and a follow-on meeting with the banking consortium. I was not present, nor do I know who attended the Eskom, or for that matter, what type of committee it is at Eskom. So unfortunately, I have zero knowledge about who attended that, what a quorum was, whether they voted in favour. I've simply got no knowledge on that.
But you know there was a meeting in the evening of that day.
I became aware of it as a result of the carte blanche show.
Members, I wanted to ask question first before you come, because sometimes you're not giving me a chance to ask questions. Just give me. I've got only two that I think, and a comment that I think would be fair. Mr. Hoa remarked on OCM rescue, according to your statement. Does this mean the banks did not give the guarantee, did not give the money, or did not agree on rescuing OCM, but Eskom was of the opinion, or was adamant in saying OCM, regardless of what is happening, needs to be rescued, and Eskom would even go beyond their principles and their policies and just pay OCM so that it gets rescued at that moment?